I want to welcome Mr. Pankaj Kumar Bhagat from IIT Madras to talk about how to patent your idea before you publish. Mr. Pankaj, you have about 13 minutes for the talk and 2 minutes for question and answers. Thank you.
Sure. Good morning, everyone. And thank you, Dr. Ganti, for giving me this opportunity. Good morning to esteemed speaker and distinguished participants. Let me share.
Sir, audio is not coming, sir.
Ganti, sir,
We can see your screen, sir. Can you switch on your PPT and yeah. You can now start, sir. Thank you.
audible? Am I audible?
Yes, you are audible. You are audible.
Okay, great. I was meeting and through the discussion so far, what I have understood is development and creation of intellectual property is very important. And what I'm going to do here is that I will try to give you a gist of how to patent and what are the processes that you have to follow, and we'll also see how we can patent even after public disclosure of your discoveries or your invention. So most of the time we see that inventors have the urge to publish their development, publish their invention or discovery that they have come up with, and they submit the papers for publication agency, and publication happens. But what happens in the publication, the prospects for patentability gets lost, because novelty is one of the prime criterion for patent. So let me take you through my slides. This is what patent is. Invention means a new product or process involving an inventive step and capable. So there are three criteria which has to be met for filing patent application. That is, there is a novelty that should be there in the invention, and inventive step, which is nothing but it should be not obvious to person skilled in the art. And of course, the third one is that your invention should be having that industrial applicability. So just to give you a brief idea about inventive step, because many people do not understand the definition per se of the inventive step. So when we file patent application in patent office, what patent office tries to do is that they try to check whether the invention is novel, whether the invention is first time in the entire world. So through that they check the novelty, and the next task of an examiner in the patent office is to see whether this invention is not obvious to the person skilled in the art. So what he tries to do is that he will try to search a document related to that particular invention published prior to your invention or prior to the filing of your invention. So he will arrange a published document which will basically be used by him to show that your invention is not obvious. And if he is able to find that there are some teachings available more than one in more than one document, then he will combine that and prove that your invention is obvious to the person skilled in the art. So what it essentially means is that when you publish your discoveries or your invention, that enters into the public domain, and that kills the novelty of your invention. So we have to be very, very careful about the publication as to what we publish, what we should retain for patent application. So let me take you through the simple process of patent protection. These are the what you call the criteria, or you can say the precaution that you have to take is that your invention, you should file a patent application first before any publication. So when I say before any publication, it should not be even not discussed in any public forum. It should not be even disclosed in through social media platform, and it should not be even posted anywhere outside the institute. Many times, even pasting an abstract lab is also considered as disclosure. So what we can do is that before publication we have to take care of this, and when we are doing this, we will be able to retain the novelty, and post that we should file a patent application. So there are simple process that we have to follow. Inventor himself is capable of doing that, and the requirement for patent application is that you should clearly outline the title of invention and the background of invention and the object of invention, through which basically general public can understand when your invention is published. So when you file a provisional application in the patent office, within 12 months you have to file complete specification, and your patent application will proceed for the examination. So, as Professor Ganti said, many times this issue is there with inventor with respect to the papers, whether they should publish first and then patent, or whether they should first patent and then publish. So this dilemma is there, with every inventor, and this is not only in India. This is this issue is a global issue. Um, uh, all researchers or developers face the same scenario. So what we can do is, when you prepare a manuscript for publication, we can use the same thing for filing provisional application. So here in IIT Madras, what we have done is, along with the invention disclosure form, we ask inventor to enclose manuscript that they have prepared for publication, and that is in sufficient detail. That is, sufficient for the purpose of filing provisional. So we use that to create a provisional draft. We have provisional application in-house, and the content that is provided by our inventors are in the form manuscript, which we use for provisional filing. So the steps are very simple. As an inventor, you don't need to write a complete draft which is in technological format. You need to just submit your whatever document you have with respect to the invention or discovery, and then leave it to the patent professional, or in-house IP cell if you have, and they will take care of it. But as an inventor, you have to take care of one thing, is that invention should not be published before filing provisional application. So if suppose inventor finds that document is not ready for provisional filing, then he can use, sometimes we tell them that you can provide us the PowerPoint presentation which you have created for presenting it to any seminar or symposium, and that can also be used as a document for filing provisional application, or any other document which you feel that that provides the detail about the invention that you have developed. So this is very simple step that inventor has to follow, and at this stage, since this is provisional stage, we don't even need to engage attorney, because attorneys will come later when they have to draft complete specification, and that has to be in technological language along with the claims. That is very important for the patent application. And the provisional application which I'm talking about is without the claim of the invention. So the provisional application that we do, that is not having claims of the invention. So these are the documents that is required to be submitted, and these are very simple document that is prescribed by the patent office. So we can use and complete this formality for filing the application. So form 1 is called proof of right, which is basically an authorization by inventor to the patentee. So in the case of universities, the patentee or the applicant is institute. So through that form 1, they authorize or they provide this right to institute for filing patent application. And form 2 is nothing but provisional or complete specification. So as I said, for provisional application, the document could be anything like manuscript document or PowerPoint presentation or any document which gives provides the outline of the invention and the detail about the working of the invention. And the form 3 is statement and undertaking. So through this, we basically update patent office that if any patents for this invention is filed outside the country or outside India. And declaration as to inventorship in the form of form 5 is basically a declaration by inventor, and they through this they say that they are the true and first inventor for this invention. And when you engage attorney, you need form 26 attorney. So all this can be done by inventor himself, and no need to engage attorney. Now, having said that, many times what happens, due to urgency or requirement for publication, if suppose you have published and you realize that this invention is really having good potential and this needs to be protected, then obviously there is a question in your mind that whether I can still file the patent application after my public disclosure or after the publication. So as per the Patent Act, we have certain exceptions through which there is a possibility of patent filing even after public disclosure. So these are the exceptions basically, and what this section says. So basically this anticipation by previous publication, that is under section 29 of the Patent Act. So this section says that anything which is published prior to the patent filing, and that is basically done without the consent or permission from the inventor, and that is done by any third party, then that will not be considered as anticipation by previous publication. So in that case, you can file a patent application.
Mr. Pankaj, sorry.
The next one is...
we have just 2 minutes to finish this.
Yeah.
Thank you.
Sure. So this is the last slide, I think, and then I will wrap up this. And the next is anticipation by previous communication to the government. So if anything you are communicating to a government, like in the form of proposal submission or anything which you have to disclose to government, by way of instruction by the government, for the investigation by the government, is not considered as anticipation by previous communication to the government. And the next one is anticipation by public display. So if anything that you have displayed as part of the government requirement will not be considered as anticipation by public display. And anything which is publicly worked, and that is again because of the requirement from the government for reasonable trial or test, that will not be considered as public working of the invention. And last but not the least, the use and the publication of your invention after provisional filing will not be considered as anticipation. So this is the section, the last one, use and publication after provisional filing, we use most. And that is when we tell our inventors that when you file provisional application first and then publish, there won't be any issue of novelty lost and losing the prospects of patentability. Now, there are some countries which have exceptions for this. For example, US provides 12 months grace period for filing patent application. So if inventor has published papers, then he can think of filing a patent application in US, because they provide 12-month grace period. Similar grace period is there in other countries also, but that is less than 12 months. That is Japan, Canada, and Philippines. So these are the countries where you can file patent application even after public disclosure of your invention. Yeah. So now you see that it is very important to sort of file and protect your invention through provisional filing, and provisional filing is very simple and very easy process these days. Even provisional filing can be done online by inventor. And here in IIT Madras, we have process through which we can and we have filed provisional application the same day after the disclosure of after the submission of the invention to the IP cell. Thank you. Thanks a lot.
Thank you, Mr. Pankaj. It was very informative, and actually it kind of tells us that we can actually patent, file a provisional before you publish in the same day sometimes. Very helpful. How do you monetize your patents? Tons of patents are filed, but few of them get into standards.
Yes. So monetization of the patents can be done through licensing, and that is the standard model adopted by everybody. But as far as standardization is concerned, there is something called patent pool, and through the patent pooling, all the patent holders who basically put their patents in that pool, and that pool is nothing but standardization, that is standard essential patents, and through that they basically monetize. But as far as individual inventors are concerned, there is a study which says that 70% of the licensing that happens in the industry, especially in academia, is through the network of inventors, and that network definitely that comes from the different seminar symposiums that inventor presents, and that is the best way to do commercialization of your invention. And you are right that there are a lot of patents that is filed and very few are commercialized, and that is done because these days there is a value to the portfolio, not to the individual patent. And when you present the portfolio to any potential licensee, that adds or provides bigger value to the entire portfolio that they have. So instead of trying to sell individual patent, we should pitch for the portfolio complementing each other. And this is very much, interesting, or you can say applicable in the case of standardized product.
Thank you, Mr. Pankaj.